Welcome to a special edition of 71 Magazine. I'm your host, John Bryanton, and joining me in the studio today is Susan Gesser, who is a local attorney who practices in immigration, public interest law, real estate, estate planning, land use, and zoning. Susan, welcome to the show.
Thank you.
And today we're going to focus on landlord/tenant laws in Owensboro-Davis County, but we're going to, really what we're going to do is sort of focus in on how it applies to evictions. Okay, but before we get started, let's first set the stage. Okay, how many families in Owensboro-Davis County own versus rent here in Owensboro, and how does that relate to the state level?
Okay, well, we have out of the 23,300 households in Owensboro, approximately 60% are owner occupied, okay, versus 40% which are renter occupied. Okay. The percentages for the state is 69% owner occupied for the state, which is almost 10% higher.
Right.
And then 31% renter occupied. So you've got just about a third of the people over the state of Kentucky renting homes, and in Owensboro-Davis County, it's 10% higher than that.
Wow. So, so obviously we have more opportunities here in Owensboro-Davis County for people to be renting. So that's why I think this topic is very appropriate, and that we talk about evictions and so forth. First of all, let's explain the three different types of landlords.
Okay. First, you have a real estate holding company. And this is a company that's the only business they do is owning property. Okay. And then it's usually set up as an LLC, which gives some immunity to the actual owner of the LLC. So if you have a person who's really trying to avoid liability, personal liability, they might set up an LLC, a real estate holding company, to have several properties that they're going to rent out to tenants. Okay. In that type of setup, they'll usually hire a property manager or some person to take care of the property for them, maybe several persons. Right. In that type of situation, it's a little harder for the tenant to get a hold of the actual person that can do the repairs on their property or whatever you may need help with. Right. Then sometimes you have smaller companies that are not as large as the real estate holding companies, also usually an LLC, but maybe a family-run type of company that owns properties and then rents out the apartments. In that case, they also will usually have a property manager, or it could just be a member of the family that handles the repairs and collecting rent and making the leases and that type of thing. And then you have individual landlords. These are usually the easiest situations for the tenant because they know who to get a hold of for repairs and who their rent goes to every month. And it's easy to get that person usually easy to get that person on the phone. Right.
Okay. What would you cite as the main issues that arise in tenant-landlord relationships?
I would say from the landlord's point of view, it's usually rent not being on time, or the tenant not paying rent at all. Right. From the renter's point of view, it's usually something that has happened in the apartment or in the house that they're renting that needs repair, or maybe pest control, something that they expect that the landlord or the property owner should take care of instead of them. Right. And getting those repairs done in a timely manner. Right.
Okay. And what any advice that you would have for dealing with a landlord?
I'd say be respectful, and I always love that old saying of you can attract more bees with honey than you can with vinegar. Right. The same goes in almost every relationship that you have as a human being, and especially the landlord-tenant relationship. Right. So if you have something go on in your property and you need it fixed, instead of calling the landlord saying, you need to come down here and fix this place is a piece of you know what, maybe call and say, I've had this issue come up in the apartment. Our plumbing is not working. Would you rather I call a plumber, or would you like to choose the plumber we use, or would you like to take care of the problem? put it into the landlord, give them a choice on what they would like to see, and read that lease. And if the lease has something that you're supposed to do when something goes wrong, follow that lease when you call the landlord and say, I'm reporting this problem. I'm going to send it to you. I'm going to take a picture of it and send it to you. Tell me how you'd like for me to address this. And then that way you've got a good rapport, a good relationship. And at that point, if, for example, you have a problem getting your rent together one month, it's easier for you to call that landlord and say, hey, I'm going to be 3 days late. Is that okay? They're going to be much more willing to say that's fine in that situation than if you are aggressive and hurtful whenever you call about repairs.
Yeah, I think it's a matter of mutual respect. As we talked before we got started, I own some homes too, and I will tell you that the tenants who we have a very good mutual relationship. It's very easy, to deal with these people, and it's very easy to deal with me. I think one of the biggest concerns you'll probably find that landlords have is when their tenants begin to lie to them. And what that does, as I'm sure you will agree, is it's a snowball effect. And so really start out just like what you said. Let's treat each other equally. This is a mutually beneficial situation that you're in. They're providing you with a home, and you're occupying their home, and that's the whole point of their business. Let's talk about preventative measures. Okay, what should a person do before they sign the lease or before they move into the property?
Read the lease. Yes. You need to read every paragraph. You need to read every section, every sentence in the lease. Because what we have to remember is this is a contract. And it's a contract that sets up the rules, procedures, and responsibilities for two people or two different entities. And this is the law for the tenant and for the landlord. I mean, just think of it as the law. And you don't want to sign onto a law or agree to a law that you can't keep. So if you just read through the lease and say, can I do every single thing in this lease? And is this fair to me? Paragraph 4, section A, is that fair to me? Then if you look at that and then you talk to the landlord and say, I'd like to have this changed. I don't think I can do this. Can I mark this out and put something different? If you all do an actual negotiation between the landlord and the tenant, it's going to be so much better because, like I said, it's a contract. And if you sign it, that's the law of the land for your apartment. And if you can't keep that contract, then that's when you can be evicted. If you have something in your lease that says you're responsible for pest control, which can be very expensive, and hey, I don't have an extra $2,000 laying in my bank account to cover pest control. Maybe that's it, but you signed on to it. That's something you need to look at. You need to look at how long the notice provision is for breaking the lease or having you evicted. So you need to make sure that that's one. It's unlawful for it to be less than 3 days, but can a person actually find a new place to live in 3 days? Probably not. So the default provision is usually 30 days. You need to look at your lease, make sure it says that 30 days. The other thing that I would do is you need to go and see the property and really take a good look at the property. If you're going to buy a car, you kick those tires and you start it up. So it's the same way with an apartment. You go in, you make sure that it's clean, you make sure you don't see any signs of vermin or anything like that. You also need to turn on the water, make sure that water runs. Look at the pressure in the shower. You also need to talk to your would-be neighbors, and especially if they have the same landlord, and see what their dealings have been like with the landlord. And then secondly, see what those neighbors say about how the utilities run. So the landlord, if they have a copy of how much the utilities cost in the winter and in the summer. And that way you're not surprised. Also make sure that you look in that lease and see if you're responsible for the utilities or if the landlord's going to be responsible for those.
I think typically people, are just in too big of a hurry.
Yes.
It's just like, where do I sign? I want to get this house. And you're right. I don't think they pay enough attention. Now, let me ask you this question. There's some people out there who may have difficulty reading these leases. What do they do in that case?
Well, they can always call us at Kentucky Legal Aid.
Oh,
We
okay.
have a grant from HUD, and we do housing counseling, which includes landlord-tenant, people who are trying to find an apartment. We can read them that lease, not only if they have problems reading, but understanding what the lease means. Oftentimes we've encountered people who don't speak the language that the lease is written under. And so in that type of instance, they can call us at Kentucky Legal Aid. They can get a certified translator to translate the lease for them. But really understanding what those terms mean is important. So it's not just being able to read it as an adult, but being able to understand it.
Right, and I think I agree with you 100%, and I think it would be a good practice to literally want to sit down with the landlord and to go through the lease. I'm sure there's just a number of people that go out there and say, we've got this 5-page lease. Where do I sign?
Yeah, and it's that they don't want to look like they're untrusting.
Exactly.
With the landlord, like, oh, I trust that you wrote this thing up fine, and that there's nothing that I would disagree with in there, and they want to look like that they're very trusting, but the most trusting person that you can be is to look at that document and ensure that you can live up yourself to what is written into it, and to make sure that the terms in the lease mean the same thing to you as the landlord, and discuss those terms.
Right. One of the practices that we do is we actually sit down with our tenant and we go through the lease step by step with them so that they understand that. And I think that's important because, like you said, they're kind of intimidated. They just figure you're going to be honest, and so they just want to know where to sign. Where if an issue comes up later, then suddenly they fall back and say, well, I didn't know.
Or I didn't read it.
Exactly.
Or, yeah.
And really at that point it's too late. I mean, because you've already signed the lease, you've agreed to these terms and so forth. So, okay. I like what you said about going in and examining the house beforehand. I mean, listen, you're going to be living there. Make sure that it's up to your standards. Okay? Make sure that the windows open up. Make sure that there's no windows that are cracked, or there's no, let's say there's no locks on the front door.
Right.
I mean, there's all these little things that they really need to slow down, take their time, and see the type of house that they're getting into. Because I think in Owensboro, although we have a lot of rental homes and we've got a lot of landlords, you have good landlords and you got bad landlords. Okay, you got good houses and you got bad houses. I think there's a lot of good houses out there. It just may take a little time to find them.
Yes.
That's all. So don't think the first place you come to is the first place you have to take.
Exactly.
Any additional tips that you might want to give for folks to protect themselves?
I would always say it's good to document everything. I think it was President Bush that said, trust but verify.
Right.
And that's what you're supposed to do. You need to do that whenever you move in. You need to take pictures, have a visual evidence of what everything looked like. A lot of landlords do a walkthrough with their tenant beforehand and have you mark any kind of thing that you see that, oh, there's a crack in the ceiling in this bedroom or whatever, to make sure that the landlord and the tenant know what they're getting in the beginning and whether there was damage there to start with.
Right.
And then again, whenever you leave your tenancy, you need to go back through, do that walkthrough, keep a copy of the walkthrough you did initially, and see if there's any further damage that was done to the property. Take pictures again to ensure that if you did do a safety deposit, that you're going to get that deposit back because there was no damage to the property.
Right. I think a lot of people, may just assume that once you give a security deposit, you're never going to get it back.
Yeah.
And I think conversely, I think you may have some landlords who think once they get that, then they never have to give it back. When in fact that's not true.
No.
You have rights as a tenant. I don't know if you can expand on this a little bit, but you have a right as a tenant to get that security deposit back.
Yes, and it's not supposed to be treated as the last rental payment, which a lot of people think it is, or if they move out under the terms of the lease, that they're not going to get their security deposit back. As long as the apartment was kept in in habitable condition, the reasonably habitable condition as it was when you first moved in, you're supposed to get that security deposit back. The security deposit is supposed to be for damages to the property, or if the last month's rent was
Right.
not paid, or late fees, that type of thing.
Right.
But you are supposed to get that security deposit back. In order to get that security deposit back, though, you do need to prove that you deserve to get the security deposit back.
And I think there's reasonable expectations of what a I mean, there's normal wear and tear that happens on properties. Whether, if you're going to hang some pictures, you may have little holes in the walls or chips of paint and stuff like this. This is normal wear and tear. What's not normal wear and tear is carpet being ripped pulled up, or holes punched in the wall, or whatever the case is. So I just think it's important that people, what you said, take pictures. Everyone now has a camera on their hip.
On their phone.
That's right. Why not just go through and take pictures? As a landlord, if I've got a tenant who comes in and before they accept it, before they sign, they're taking pictures, listen, these people know what they're doing.
Right.
And let me tell you what, to a landlord, that can be a good thing or that can be a bad thing. But as a tenant, you need to protect yourself, and that's a perfect way to do that. And that's getting that documentation that you will need, further down the road. And I'll tell you what, if the landlord's smart, he'll take pictures too.
Yes, and you almost expect the landlord to take pictures.
Right.
So that's why you really do need to do that.
Right. Okay, now let's discuss evictions and forcible detainers.
Okay.
What reasons can I be evicted?
For when you have a lease, if you break one of the terms of the lease, and you're given notice that you have broken that term, the landlord then can set in motion to evict you. That could be a black and white issue, like you didn't pay rent.
Right.
Or it could be an issue that is not so black and white, like a lot of leases have a provision in there that you have to notify the landlord if you're going to have someone else living on the property or staying there long term. And again, this is one of those places where you really need to read that lease, because the definition of what living in your apartment is going to be different from lease to lease. But usually it's 7 or more consecutive nights of someone else staying on your property. So if that's the case, you may have an argument. No, I didn't have 7 consecutive nights of someone being here. These are my children that I get on weekends. They only stay 3 days in a row at the most, and then you have an argument to make. So you don't really know if that lease term has been broken or not. Right. So for that, the landlord gives you notice. They say you've had someone else living on your property that's not on your lease. We're going to start eviction proceedings. Depending on the notice provision in the lease, it could be as little as 3 days. The default, if there is no lease, is 30 days. And they have to send you this notice, and it has to be put into your hand or mailed to you. It can't just be dropped off somewhere and or put into the newspaper. It has to be given to you. Right. So then you have 30 days, and if you can resolve the issue with your landlord and stay there, it's hunky-dory. That's fabulous. If, however, it has not been resolved and you have chosen to stay in the apartment, a forcible detainer action is taken in district court. This is where the landlord sets forth what terms in there that are mirrored from that notice that were broken. And then there's a hearing in front of one of our 3 district court judges. The judge then decides if the tenant broke the lease or not. If they have broken the lease, then the court gives them 7 days to move out of the premises. On the 7th day, their belongings can be removed, but they have that extra 7 days. Then that proceeding is more or less over. You can't ask for damages in that proceeding. That's a separate issue. If, for example, the landlord says that there was property damage, they can either take self-help measures in retaining that security deposit, or if there are further damages, they can sue in small claims court for those. The same thing on the other side. If the tenant believes the landlord has done something to their property or has done something incorrectly, they can sue in small claims court as well.
Okay. Okay. So let's give a short scenario here. You've got somebody who is renting a place, and the tenant or the landlord comes to them and they're say, hey, because of this, I'm going to evict you, this and that. First of all, that's got to be a scary moment.
Yes.
Okay. It would be for anybody. And second of all, it can be resolved.
Yes.
Okay. But they don't have the means. Maybe they don't have the level of understanding to try to discuss this with them. Are there services available when it gets to this point? I know that you said that there is some services available to read over the contract, but is there services for people who are running into issues with the landlord to where they can call and talk to someone?
Yes. Okay. Again, Kentucky Legal Aid, they can call our intake line, which is 1-866-452-9243. And we have attorneys that are on the phone, that answer the phone and talk to the person about the problem. They could actually give that person advice. If they don't think that that's sufficient, then they will refer them to our office to come in and talk to us in Owensboro.
Okay.
And then we can call the landlord and discuss the issue with the landlord. We can see, oftentimes we can look at that notice, and on that notice it will have that they can have an informal hearing within 10 days. Well, like you said, that tenant is nervous. They just get this notice and they don't even look at that little sentence at the bottom of the page. It says, if you want to discuss this and have an informal hearing, call us or contact us within 10 days. It can be that we notice that and we say, hey, you need to call and send a letter to have this informal hearing, and then see if it can be resolved before we even get to the forcible detainer.
Right. Okay. Well, that's good, because I know that, like we said, any time that something like this is happening, I think it's stressful for not only the tenant, it's stressful for the landlord, I think, too, because now we have a confrontation.
Yes.
And no one wants confrontation.
No.
And, again, I think we go back to what you said earlier, open dialogue, keep it all on the up and up, and get to know your landlord if you're able to. And I understand, there may be somewhere landlord may be several tiers up, but if you have an opportunity to get to know your landlord a little bit better, do so. I think it's going to be much easier to work with them when it comes to that.
Yes, and I think that as a tenant, you need to understand that a lot of times when the landlord owns this property, and a lot of times that property is mortgaged.
Right.
So if they don't get their rental payment, they can't pay the mortgage.
Right.
And so I think if you come to the point where you're having that discussion, and you can have a discussion after that eviction notice goes out, and you can come together and you can say, hey, look, I've got a mortgage to pay, and that's why I needed the money. And that puts the person in a more comfortable feeling of, yes, I should have thought about that. I know you need your money on time, so that I'll have a place to live, because if something happens to your mortgage, I won't have a place to live.
Yeah, because I think it's it needs to be a mutual understanding. This person wants a house to live in, and this individual wants to rent their home. I don't think there's any landlord out there who wants to see their homes vacant.
No.
Okay.
And they don't want to have to pay an attorney to do the forcible detainer action.
Exactly.
Because of the 3 types of landlords that I named earlier, the only one of those landlords that can go to court for themselves is the individual landlord. And if you have a holding company or a small company, anytime you have an LLC, you have to hire an attorney to do the forcible detainer action for you, and that costs the money.
Exactly. Okay, now let's talk about the Uniform Residential Landlord-Tenant Act, okay? Describe what is in this act.
Well, it is a default rule that is used by several localities in Kentucky. One of the great things about this act is that it sort of forces the landlord and the tenant to keep that open communication. So, if I have something goes wrong in my property that I'm renting, I can tell under Ultra, I'd have to tell my landlord, and the landlord has 14 days to fix whatever item this is. On the 14th day, if they haven't fixed the item, they can say, okay, landlord, I gave you 14 days to fix this. I'm gonna fix it myself. I'm gonna take that money out of my next rental payment.
Makes sense.
And it's just the default rule, and that's the way it goes. And we don't have that here, so you can't use that right now.
That's the whole point of this needs, what you're advocating obviously is that that this is adopted
Right.
in our county.
That would be fabulous.
Okay.
There, obviously, it's in place in those big cities in Kentucky, like Louisville and Lexington, but also places like Barberville and other places
Right.
in Kentucky have adopted it. When you adopt it as a city or a county, it has to be adopted in full. You can't just piecemeal it.
Right.
It's just the whole thing. It really spells out the relationship between the landlord and the tenant, so everybody knows what's going to happen. It tells that the tenant will be in habitable housing, and that's a rule, that they're going to pay rent as it was agreed to, that they're going to keep their rented space clean and safe and dispose in waste in a clean, safe manner. A lot of the provisions of the law are common sense,
Yeah.
but they are codified common sense. So it just makes it clear the duties and responsibilities of the landlords and the tenants.
Yeah. Well, here's a real simple question: who benefits from inducting this act?
I think both landlords and
Everybody.
tenants. Yes. Yes, exactly.
So why is this not? You and I are sitting here saying this is simple. Let's do this. Why can't we?
Well, you just have to have either the city, being our city commissioners and our mayor, adopt it, or our county adopt it.
Would it not be
and
better
that's
if the county adopted it?
It would
Because
be, because that would include
that
the
would
city.
include the city, right?
Yes, yeah.
Okay.
So that would be fabulous.
Okay. So what efforts have you gone to try to get this enacted?
We've spoken. We've had at our last Housing 101 session, we had people sign a petition to send to our local leaders to have it enacted. I know Sylvia Coleman and the Human Relations Commission have also made efforts on that as well. We would love to set up a meeting with some of our leaders and explain the ordinance and what would have to go on and have them pass
Adopt it.
that.
That's
That would be
right.
great.
Well, listen, Susan, this has just been, I think it's been great news. I think it really is. And I really don't see, from my standpoint here, not knowing all the super details, but from a standpoint right now, I think it's ridiculous that we don't adopt this. It makes it easier for the landlord, it makes it easier for the tenant, it spells everything else, makes it much smoother going through the court system, I'm sure. So to me, it's kind of a no-brainer. So, but listen, if any of our viewers or people who are listening, if they would like additional information, where can they get a hold of either you or the Kentucky Legal Aid?
Our phone number, again, is 1-866-452-9243. We also have a website, www.klaid.org. Also, there's a website for the state of Kentucky where people can get news on housing and other issues, and that is www.kyjustice.org.
Okay, Susan, thanks for joining me today.
No problem.
Okay. And thank you for joining us for this special segment of 71 Magazine. Have a great day.